Hello, my name is Cody Price, and I just want to welcome everyone. It is now 1 o'clock, so we will begin our presentation shortly. Today on January 21st, we will have our presentation on planning ethics across the country, given by Dwight, Merriam, Anna Breinich, and Ben Frost. For help during today's webcast, please feel free to type your questions in the chat box found in the webinar toolbar to the right of your screen, or call 1-800-263-6317 for content questions. Please feel free to type those in the questions box, and we'll be able to answer those throughout the presentation. Here's a list of our participating chapters, divisions, and universities. I'd like to send out a personal thank you to the Northern New England chapter for sponsoring today's session. So in 2011, we started a change to our Webcast system. When you go to log your CM credits, everything will be listed underneath the Ohio chapter, and all the webinars that are listed on the website are already submitted for CM credit, so it's just waiting for approval, which you'll be able to see on the website if it's been approved or not. There's also a new rating system out, which either rates the system as an introductory, advanced, or an allied session, and you can find out and read more about that on the website. Our next webcast will be next Thursday on January 27th on Religion, Zoning, and the Court, an overview of the RLUIPA. This is for law credits, so if you need those, please register for that session. I also want to make some point outs on February 17th. We've had a new edition for the Planning for an Aging Population, and February 23rd, Developing Aging-Friendly Communities. These were just recently added, so if you're interested, please go to the www.utah-apa.org/webcast website and then select your webcast of choice. March 11th, Urban Retail was also recently added, so if you're interested in that, please go to the website and register. To log your CM credits for attending today's session, please go to www.planning.org/CM. Select activities by date, and then underneath Friday, January 21st, you'll find planning ethics across the country. This is up now, so after the presentation, you may go there and log your credit. So at this time, I would now like to hand it over to Ben Frost, who will be introducing our speakers for today.
All right, thank you, Cody. And good afternoon, everyone. My name is Ben Frost. I'm the Director of Public Affairs for the New Hampshire Housing Finance Authority. And I'm also the Professional Development Officer for the Northern New England chapter of the APA. Joining me this afternoon is Anna Breinich, Director of Planning and Development for Brunswick, Maine, and President-elect of the AICP. Is that right, Anna?
Yep, it is.
Great. And she also serves with me on the executive committee of the Northern New England chapter. Also with us, last but by no means least, Dwight Merriam, FAICP, and former president of AICP, and founding partner of the Robinson & Cole Land Use Group, widely known and widely admired and respected as an expert on planning law. Good afternoon, Dwight.
And apparently getting wider as I get older here. So.
Well, I want to do a short roadmap for where we're going to be going this afternoon. This is ethics around the country. We want to talk, starting off, talking about the AICP Code of Ethics and Professional Conduct, and then briefly talk about the ethical codes of other professions with whom planners typically work, such as architects and landscape architects and professional engineers, and then finally attorneys. We'll also take a quick look at some state statutory code examples and what they mean. We're not going to be going into great detail into those, but just to give you a sense of how they vary throughout the country. And then we'll be going through a host of scenarios, and we do have far more scenarios in this presentation than we could possibly cover this afternoon. So we encourage people at the close of the program to take a look at those that we didn't cover and discuss them among yourselves. We also have our contact information available in the end of this program. So if you want to email us separately, if you've had some thoughts, feel free to do so. Questions, we will save some time at the end of the presentation for questions, but we want to welcome your questions throughout this and to make it as lively and interesting as possible. And so, as Cody suggested, please use the question box on the toolbar to ask us questions or make comments on things we've said. We'd appreciate that. So, Anna?
Yeah.
What do people say about ethics?
I think Mark Twain says it all. I really do. He is so common sense, simple to the point. You always do what's right. And I have to laugh every time I hear our police chief around town saying, you just many, many times over, do the right thing because it's the right thing to do.
Well, I like George Bernard Shaw's quote here, ethics are what you do when no one is looking.
Well, you know, Thomas Jefferson is one of my heroes, so what he says is, whenever you do a thing, act as if all the world were watching, which, you know, it seems different from Shaw's, but I think it's really saying the same thing.
And,
well, of course, then there's wiki everything, right, Anna? And here's a Wiktionary term for ethics, the standards that govern the conduct of a person, especially a member of a profession. Let me make a couple observations, and then Ben, maybe we can start going over the code. And I want to thank you, Ben, here in this forum for all your hard work in putting this together. It's been fun and enlightening and interesting. One of the advantages of doing a seminar like this is it causes us to go back and look hard at these issues. First of all, the keys to some of this are just applying good common sense. But that's difficult at times because some of this is so ambiguous. I've got a quote here in this slide from the Ethical Principles of Planning, which I'll talk about later, not now, but we do have a special set of ethical requirements to guide us. There are three observations I would make, and I confront these every day like most of us do. The one that I use the most is what I call the light of day test, which is sort of this combination, Ben, your observations about Jefferson and mine about Shaw are really not far apart, although they seem to be on their face. And I call it the light of day test. And that is, if you're doing something, you're feeling a little uncomfortable, ask yourself, how would I feel if my closest peers, the people I respected the most, knew exactly what I was doing or about to do? What if this saw the light of day? The second thing I use, believe it or not, still today after all these years, 40-something years in planning, in one capacity or another, is the golden rule. I always try to think, well, how would I feel if I were on the other side of this? And I learned about it. Finally, I learned a little something many years ago in pilot training, and that is they tell young pilots in training, when you get lost, you need to remember the 3 C's. And I think we can apply this to planner's ethics as well. They tell you to climb, to get up above the problem. They tell you to communicate, to talk to somebody, which is what I always do when I'm troubled. I go find somebody else and say, I'm feeling uncomfortable about this, what should I do? And that brings us to the 3rd C, which is to confess, to tell people, somebody, that you got a problem and you need some help. And I don't know, Anna, maybe this is a point where we should get into the code itself.
Sure. As members of AICP, I think most of us, if not all of us, should realize that we have a code of ethics and professional conduct to follow. The light of day test that Dwight was just talking about is so evident throughout the code. It really is. What has been reworked in 2005 is just to simplify the language that was in there prior to that and just put it into 3 basic sections. The aspirations, what we want to be, what we should be doing, our rules of conduct, what we must be doing, that's the enforceable part, and the procedures, what happens basically if we screw up. This is what we have to go through. Hopefully nobody gets to that point. As we take a look at the aspirations, our first aspiration is to the public. We serve the public interest first and foremost. Everything kind of comes underneath that. We do not pay attention to special interests, but the public interests must prevail. For each of the aspirations that we're talking about, and there's 3 of those, we have specific principles. And I just wanted to kind of highlight a couple of the principles for each of the aspirations. For serving the public interest, I think this principle, A1F, really says it all, that as planners serving the public interest, we should be seeking social justice for all, making sure that the needs of the disadvantaged are addressed. We should be doing that with we should have that in the back of our mind with any type of planning activity, any planning decisions that are made, either public sector, private sector. It still applies. Our responsibility to our clients and employers, our next aspiration. Basically, we owe responsibility for those that employ us. And that responsibility is to make sure that we are qualified to do what we have said we're going to do, and that we do it in the best interests of our client or employer, never forgetting, though, that the primary responsibility is still to serve that public interest. And we're going to talk a little bit more about this later as we start looking at codes of other professions, and maybe, for some of us that might be wearing more than one hat, as in the case of Dwight at times, or had been at times. He will get more into depth about that. One of the principles under that aspiration, Code A2C, it's a principle that elaborates on dealing with conflicts of interest. Avoid them. I mean, and most of us know this, even an appearance of a conflict of interest should be avoided as much as possible. Again, we're going to talk more about that as we go through the scenarios. Lastly, our responsibility to our profession and colleagues. This is just basic courtesy, respect for those that we work with, for our profession as a whole. What can we be doing for our profession? How we present ourselves. It's just being able to work together. And a couple of principles on this one, using fairness and professionalism. You don't want to cut somebody at the knees when you're reviewing a plan, when you are, and it doesn't matter what profession, it isn't just planners, but architects, the design profession that you're dealing with. You always want to make sure that you are respectful people. Lastly, the final principle that I wanted to mention is A3J. Again, remembering that we are to give of ourselves, give back to the profession. Now,
let me just ask you a question here to reinforce this here. These aspirational principles, they're not really the ones that are enforced, are they?
No, and that's the rules of conduct that we're going to go right into. Thank you. There's 26 of them altogether. Again, being common sense in nature, and they're based upon those aspirations and principles. Just to highlight a couple of them, Code B6. This one goes back to the conflict of interest and personal gain. I'm not going to read it to you. And let's see, one more slide. Here we go. Code B6. And conflict of interest and personal gain. It's pretty simple in concept that, you're not supposed to benefit directly, personally or financially based on a decision that you have made or have been involved with. It's not always simple in practice. Again, we're going to talk more about that in the scenario. So this is kind of a refresher on the code as we talk through the scenarios later on. Code B2 or B10. And I believe this, yeah, the last one. Again, it's pretty simple to interpret. Always be fair and professional in your review of others' work. It's how, this one, it shouldn't be that difficult to follow that general rule. The last section of the code procedures. As I mentioned before, this is what is followed if you either have a question of the executive director, who is our APA's executive director, CEO, Paul Farmer, who is our ethics officer, or if someone files a complaint against you. The procedures, the code procedures, are in two forms: informal and formal advice. Only the ethics officer can issue advice. For a long time, members thought that our PDOs were the end-all when it came to ethics questions. Don't even ask, in our case, in Northern New England chapter, don't go to Ben. Ben doesn't want it. Always go.
Don't go to me.
Always go to the executive director. He's very reachable. It can be either a phone call, it can be in an email, doesn't matter. As informal, it is non-binding. If it is formal advice, that's when we get into more of the binding advice making with formal findings and forwarded on to the ethics committee. There's also
Anna, I want to jump in there, and because this is Ben. I've been asked for advice on different things before, and I follow that rule. Although, you know, it's I think important not to put people off, and as a friend and colleague say, you know, I think this, but you really need to be consulting with the ethics officer, and you need to get in touch with Paul Farmer on that. And they've done that, and it's been helpful.
Yeah.
And you know, one of the things we discovered in preparing for this, and maybe Anna, you were researching it further, in many other professions, these advisory opinions are posted permanently, so you can go back and find out what happened, and the disciplinary actions are posted. But I couldn't find them online when I searched for any of these past records. Did you ever find them?
No, I didn't, and that's something I'm going to follow up on, and we may be just missing them, but that may be something that we should be taking a look at as well as AICP. And it's interesting, Dwight, that you mentioned that, because even in going back to look at, we're going to be talking about the state-specific ethics acts that need to be followed as well. And for instance, in Pennsylvania, they actually do an annual report every year, and within that annual report are the specific cases. So there, again, there are findings that are posted online as well as in hard copy.
But do we have lots of cases in this area?
No, we don't. Thank goodness for that. We had in 2009 a total of 11 cases, and the 2010 has not been compiled yet. I did check as recently as yesterday. It's in process, but you know, having serving on the commission, we generally at least see composite numbers. We don't see anything that is specific to a complaint. So the AICP Ethics Committee gets involved, gets reports back from Paul as to what the status is of the actual cases. So it's a good thing there aren't that many. Hopefully it stays that way. But there can be serious consequences of your actions, and that we have had instances where professional planners, AICP members, have been censured and/or suspended for you know, a given amount of time. There are different actions that can be taken. And with that, I'm going to to pass it on, Dwight, to you. I think.
Well, I did when I was looking around for more information on records of disciplinary actions, I stumbled across these two resources. These apparently were prepared. They're flashcards, online flashcards, very cute, that were prepared for the AICP exam preparation, and they're worth taking a look at. But let me close out this section by talking a little bit about everybody else in planning other than the certified planners. And that is that we do have in the American Planning Association a set of principles, ethical principles in planning, as adopted in May 1992. And it starts out by saying that this statement is a guide to ethical conduct for all. And by that it means citizens, everybody, for all who participate in the process of planning as advisors, advocates, and decision makers. It presents a set of principles to be held in common by certified planners, other practicing planners, appointed and elected officials, and others who participate in the process of planning. And then there are three sections within that. One of them is planning process must continuously pursue and faithfully serve the public interest. What you pointed out in the aspirational part of our code is first and foremost that we must continuously strive to achieve high standards of integrity and proficiency. And interestingly, the third one, it says that APA members who are practicing planners have got to stay continuously educated. But you know what? I think we're missing something there. It doesn't say anything about keeping our elected and appointed officials educated and up to date. I have never seen anybody actually discuss these with their commissioners, and I trust that many of our listeners do. But if you haven't, you might go back to the website. We've given you the web address. Take a look at it. Put it on your agenda to discuss, and just have an open discussion about some of the issues raised in these ethical principles of planning. Ben, we were talking as we prepared for this by way of comparison about what's going on in other design and design-related professions. What do we have there?
Well, I wonder if before we move on to that, we could take a question, because we have one.
We have several, actually.
This is from Anna Ruiz, and the question is it ethical to solicit interest or support from stakeholders who can advocate for your project? On the flip side, if you do not inherently support a decision or a recommendation, is it ethical to solicit members of the public who will advocate against the project or decision? What do you think?
I wouldn't do it.
Well, excuse me, you would or would not?
Would not.
Well, it doesn't say, is it the public planner?
Yeah.
Is it ethical to solicit support from stakeholders who can advocate for your project? I think the public planner's position might be different than the private planner.
Yep.
But yet I think an argument could be made for the public planner's side of this. Remember the late Paul and Linda Davidoff and the classic that most of us read in planning school about advocacy planners. I knew Paul Davidoff personally and admired him greatly. We did a book about his work in 1984 for APA. And the theory of advocacy planning was that many of the constituents of planners are people that have no voice. Some of them are generations not yet born, or they don't live in the community, for example, when we're looking to increase affordability. If you believe in that role as a planner, as advocate, particularly for constituents with no voice, then you might find it entirely ethical to seek out support from a broader base for what you're trying to do for those folks. I don't know.
And I think that it's ethical if you are soliciting from in a group situation. You have for instance, you have a controversial project, and you want more public input. So you call a public meeting, public workshop session on that project. And so you are soliciting additional information, which could be in the form of support or not. But what you're doing is opening it up. You're not making a personal phone call as a public sector planner and saying, gee, I really hate this project. I really need your help to come out and speak against it. To me, that's when you're setting the stage for disaster.
Again, light of day test.
I think you need to ensure that there's balance in your approach to this. Dwight, I agree that there is a difference, an important difference and distinction between the publicly employed planner and the private consultant planner. Obviously, if you're a private consultant, even though as a planner you're serving the public interest, you are also serving a client on a particular project. And if you, I think there is an expectation that you would seek out people who would support your project. I would be surprised otherwise. But for a public sector planner, I think we need to ensure that there's balance. But take a look at the code as well. You know, seeking.
Well, I think you hit it, Ben, and that is that it can't be to the exclusion of public participation broadly. I think that's the key to ensuring that you're ethical. It can't be that you are excluding others who would have a contrary opinion. Somebody asked a pointed question here. Do you see it there on our page, Anna?
Yes,
is there a statute of limitations for making ethical charge? I don't know the answer to that question.
I'm not sure about that, but I could get back. It would be in the actual procedures. Maybe before we finish this, I can just kind of skim through the procedures real fast. I don't believe so, but...
and of course, we're talking about the AICP code, right?
Correct.
That's
right.
Yeah.
And there may be something, depending upon the state that person is in. Because we always have to remember we do have state ethic regulations or state ethic acts that we also have to abide by.
That's right, and those would be very different, potentially, and there probably would be a statute of limitations with a state or local code. And I have the code in front of me, and I'm looking for a statute of limitations, and I can't find it yet.
All right. How about the AIA, Ben? That's where we're going to go next.
Well, we're going to talk a little bit about the other design professionals that planners deal with. And looking at the codes of ethics of the AIA and landscape architects and professional engineers, they are in some ways very similar to the AICP Code of Ethics, but also different in a very important way, because they are all written from the perspective of the private sector, the assumption being that in these cases, for the most part, these professionals, architects, landscape architects, and engineers are going to be serving private sector clients. So you see that colors the language and the tone, and also the aspirations, if you will, of each of these codes. The AIA has a structure that's very similar to the AICP code. It's broken out into canons and ethical standards, which are aspirational principles, and then rules, which are mandatory and enforceable. So the obligations that an architect has are to the public, yes, to the client, to the profession, to colleagues, and to the environment. And these are the canons, which are like the AICP's aspirational principles. There's also in the AIA Code of Ethics a balancing of confidential client communications. Now, Dwight will later on talk about the attorney-client privilege. There is no, at law, recognized architect-client privilege. But under the AIA Code, there is an expectation that an architect will keep those things confidential that are presented in confidence to the architect by the client. Unless, of course, not doing so would violate some other code provision. And among them are things like violation of the law. There's also, the AIA Code is steeped in fairness, which is really what Dwight was talking about in the Golden Rule, fairness and competition with other architects. And that, of course, and this is something that planners don't typically deal with, it includes copyright protection for the works of architects. And these are, as I said, these are enforceable by the AIA, and they do have published opinions and enforcement actions.
Yeah, Ben, you raised, as we were preparing for this, of course, we were swapping materials, and Ben had come across a very interesting case about an architect that had basically designed a house that was just way over what was originally contracted for in size and in cost, and kind of what was interesting about it, he was pretty much dealing with the wife, the architect, and then it was noted that there was a romantic relationship with her. So I was kind of surprised he was only suspended for a couple of years on this one. But Ben, you might want to give a little bit of detail on that.
Yeah, the architect.
What, the romantic relationship part, or what?
Well, I don't know.
I don't know
You might know more than we.
The architect had been hired by a couple, a married couple, to design a 3,500 square foot house, and it turned out he was communicating primarily with the wife, and he produced plans for a 7,000 square foot house that would be twice the cost of what the couple had hired him for. And there was multiple communications, and he gradually winnowed it down to something like 6,500 square feet, still twice the cost that was originally contracted for. Meanwhile, he was engaged in an affair with the wife, who was also his client too. And one thing that the AIA noted in its sanction against him, suspending him from practicing or from membership in the AIA for 2 years, which professionally is very important for an architect. They noted that he should have disclosed his conflict of interest, that is, that he was having an affair with the wife. Now, I'm not sure how comfortable he would have been doing that, but that was one of the points that they noted.
Interesting.
Now let's move on to landscape architects, and you see similar principles to the AIA codes, the same structure and same private sector perspective as the AIA code. But there is within the, as you would expect for landscape architects, there's a greater emphasis on environmental concerns. There's also, and I found this interesting in comparison to the AIA code, there is within the ASLA Code of Professional Ethics a recognition of possible public sector employment. But that's really only in reference with conflicts of interest. So a landscape architect who is working for a firm should disclose and get permission to do public sector work for compensation before proceeding with that. There are, as I said, there's, this is, the ASLA code is steeped in what they say, honesty, dignity, integrity, and just like the AIA code, the golden rule, fair dealing with other landscape architects. And this, too, is enforceable against its members.
Well, Ben, I tried to find a case of an ASLA member behaving badly. And like APA and AICP, they don't seem to publish their disciplinary actions on their website. I searched long and hard. Maybe there's an ASLA member online here who can tell us otherwise. But I did find the several states, most of the states have licensing requirements and they have disciplinary actions, and they often follow ASLA rules. And I did find one by way of example, which is very similar to our B16 requirement under our code, and I'll get to that in a minute. Here was a ASLA member who was accused of and found had violated the code by being negligent and having willful misconduct in his practice because he failed to provide a landscape design plan to the client after he had already been paid $2,900. Our B16 says that we as certified planners cannot accept work, paid or unpaid, that is pro bono work, doing work free. We can't take even free work if we can't produce the product in a timely manner. So and we see that across these professional codes as well. You can't be taking on work that you know you can't do in a timely manner, your clients.
Yeah, it's good advice and it's enforceable. Let's take a look at now the Code of Ethics for Engineers, and this is from the National Society of Professional Engineers. Same sorts of considerations, and I asked, do you see a pattern? Well, yes, of course. It's based upon the ethical standards that we subscribe to as a society, really. It's not just professionals, but there are expectations of behavior, and these are what drive the language of our codes of ethics. Like landscape architects, and without poking fun at engineers, the Code of Ethics for engineers reads like it was written by an engineer. It is really straightforward. It does not leave, I think, a lot of room for ambiguity. But it does talk about adhering to principles of sustainable development, which I thought was particularly interesting. And it defines, there's a footnote in the Code of Ethics that defines what a sustainable development is. And it focuses on the sorts of things that would be of interest to engineers, such as land development, waste management, and the like. Interestingly, as I took a look at the history of the Code of Ethics for Engineers, I found another note on the current code that refers to old Code 11C, which doesn't appear anywhere in the code now, and the numbering scheme is all different. It was changed in the early 90s. But there had been a ban on competitive bidding in the Code of Ethics for Engineering, and that was challenged by the U.S. Department of Justice, and the Supreme Court struck down that ban on competitive bidding as a violation of the Sherman Antitrust Act. Now, the reason that engineers argued in support of that was that to have competitive bidding would encourage engineers to make deceptively low bids. And you often hear jokes about the quality of work as being reflective of, well, that was low bid. Well, that was the concern that they were trying to get to. And they really wanted to have engineers hired on the basis of the traditional basis of qualifications of assessment. But that was found by the U.S. Supreme Court in 1978 as a violation of the Antitrust Act. Now, the court was careful to note that the Act does not require competitive bidding. So municipalities, any unit of government, you don't have to do competitive bidding unless you have a state or local law that requires it. It only prevents the Society of Professional Engineers from prohibiting it. Now, Dwight, want to move into the realm of lawyers?
Yeah, I would just quickly answer a question that we got from somebody of whether there was somebody who's a member of ASLA as well as AICP asking about conflicts between the codes. The ASLA code is very similar to ours. I encourage our listeners to go look it up. But it pretty much parallels ours, and I don't see any conflicts between them. The ABA, I'm going to talk about the American Bar Association rules because planners need to know about this in order to work better with their lawyers. And I'm going to tie this into the AICP Code of Ethics and Professional Conduct at the end. There are many good parallels between what lawyers are required to do and what planners are required to do. And part of this is to help our planners understand what the lawyers' responsibilities are and to point out where, for those of us who are both planners and lawyers, where we may have conflicts between our codes. First off, let me just say that beware, that what you say to your government lawyer or your outside consulting lawyer may not be confidential. There is been some erosion of the government lawyer-client confidentiality principles, and it's in a state of flux. And so we need to be extra careful in all types of communications. And our current situation is this. There's uncertainty in the law. There is a politicization, if you will, of attorney professionalism. In other words, the politics is playing against the profession. And finally, the American Bar Association is doing what it can to preserve the attorney-client privilege. And in fact, in 2005, the ABA adopted a resolution positively and expressly supporting the preservation of the attorney-client privilege and the work product doctrine. They are two different things, and we need to understand what the differences are and what each means for planners and their relationships with lawyers. We're a rights-oriented society. There's a lot of litigation. We have to contemplate litigation from the time we hear about an application coming in because who knows what can happen. There are three distinct areas in this subject matter. One is the common law or judge-made law of the privilege of communications. Another is the common law, again judge-made law, of the lawyer's work product, what the lawyer produces, as being protected from discovery. And finally, our codes as lawyers, the model codes, the Code of Professional Responsibility in the various states guide this conduct. And here are the big questions. What are the protections that are available under the privilege and the work product? Is it the same for public lawyers as it is for private lawyers? We'll find out it really isn't. Should it be the same? And we'll talk about the public policy implications of that, at least briefly. First of all, under attorney ethics, there is confidentiality generally. And here's the preamble from the model rules directing lawyers to keep in confidence the information they receive and to zealously protect and pursue the client's interest, including the protection of those communications. And here's the model rule at 1.6 that talks about a lawyer not revealing information relating to the representation of the client unless the client gives informed consent. Notice, consent, informed. They have to know what they're giving up when they give that up. But look at this under 1.6b6. A court may order disclosure. And there may be, in fact, federal, state, and even local laws that require disclosure of what otherwise would be confidential information. Comment 13 to this rule acknowledges that the lawyer may be ordered to produce this information. And I had this situation come up in a confidentiality of a consultant, Ben and Anna, and I didn't tell you about this during our preparations, but here was the case, and just think about this. The representing a developer, we put an environmental professional on site working for me to protect under the attorney work product privilege anything that he found. And guess what? He found an endangered plant. And he believed that he was legally and ethically obligated to reveal to the state the presence of that plant. And I agreed with him. It looked like the statutes require if you find one of these things, you have to report it. So he said, what are we going to do? And so we called the client and said, here's what we found. Here's what we think his legal and ethical obligations are. We want your permission to tell the state that this plant exists in this location. Fortunately, the client said yes. If the client had said no, I'm not sure where we.
Yeah.
Well, I'm not sure where we would have gone. But let me tell you what the lesson learned from that was. Planners, environmental planners, regular land use planners like yours truly, in their contract should specifically say, I'll maintain the confidentiality, but if there is a federal or state law that requires me to reveal this, or I'm ordered by a court, et cetera, consult with your local lawyer friend as to the language, you ought to put a carve-out in that contract so that there isn't any ambiguity when something like this arises. We did not have that in the contract with this consultant incident.
And
Dwight,
Dwight,
you gonna say something?
Yeah, what happens then if you're wearing both hats? That for some reason you are, like, you kind of switch on and off. Sometimes you're acting in the capacity of an attorney, and sometimes you're acting in a capacity of a planner. So,
well,
what
I'm saying is that what lawyers have learned, and planners can learn from this lesson, is that the retainer agreement, the agreement under which you undertake your work, is extremely important. You need to identify exactly what you're expected to do, when you're going to do it, what it's going to cost if you can determine that. But you also need to have, as I said, a carve-out for this type of issue. I'll protect the information, but if I discover something that I'm required under federal, state, and local law to reveal, then I'm going to have to reveal it. Which really brings us to the next business, this whole privilege of confidentiality. And there's an ancient book by Wigmore on evidence that defines the privilege in this way. Where legal advice of any kind is sought from a professional legal advisor in his or her capacity as such, the communication relating to that purpose made in confidence by the client at the client's insistence permanently protected, is permanently protected from disclosure by the client or the legal advisor, except where that client waives the protection. In other words, they both have that privilege. And so here are some of the, in the next couple of slides, I just want to sort of encapsulate the arguments both ways, because it does point to the concerns that we have about the loss of the privilege or the erosion of the privilege. Here's why we favor, why lawyers generally and society does favor this lawyer-client privilege. It means communications are going to be open. If we don't have it, I'm really concerned that our planners and managers and the like are not going to tell us everything. And the lack of getting good representation is ultimately going to work against government carrying out its work. But now here are the arguments against a full lawyer-client privilege. There'll be some privilege, but maybe not as much as we have today. Who's the client? The public's the client. The public is entitled to the truth. There is a higher duty owed to the public than to the individual. And simply, public officials are different than ordinary citizen clients, and our freedom of information laws, sunshine laws, and the like, as they're called in some states, really point to there being no secrets. And finally, and increasingly today, government lawyers are required to disclose information when they get it. So in summary, the differences between the work product doctrine and the attorney-client privilege: the work product doctrine protects, just like what it sounds, documents and other efforts of the lawyer, and the attorney and the client must agree together to waive it. The attorney-client privilege, that is between you as a planner and you as the lawyer who's working with you, belongs to you alone. You have to decide whether you want to waive it or not. The lawyer doesn't have to join in that decision. And unlike the attorney-client privilege, the work product privilege is not waived when you share information with other people. So be very careful in this area. It is a shifting landscape. We really need to err on the side of minimizing communications that may be discovered later, but still making full use of your lawyers. And let me just turn back to a couple sections of our Code of Ethics and Professional Conduct. And Anna, you were pointing out our rules of conduct under B are the ones that can bring disciplinary actions.
Yes.
And look at number 1. We shall not deliberately or with reckless indifference fail to provide adequate, timely, clear, and accurate information. Well, I'm not sure what adequate means, but if you're functioning as a lawyer, you may not be able to carry out your obligations to the client and be quite that forthcoming. Number 3, it says you can't accept an assignment where you've taken a different position in the last 3 years. And Ben, you're trained as a lawyer. You know, we were joking about the fact that lawyers change their position week to week. But the fact is that land is unique, and lawyers are required to represent people whether they believe in their positions or not. That's part of our code, is to represent all people equally as their needs arise. But I can think in some areas where something like vernal pools, which are science is not completely settled, you indeed can take contrary positions in less than 3 years. depending upon the landscape. So there are problems there. And finally, the last one that I think is a real problem is B8, dealing with private communications and confidentiality. And our AICP code talks about custom controlling. Well, I think custom is a kind of a vague term to use here. So my advice, if you're one of these combined ASLA or AICP or ABA and AICP or whatever the combination is, or professional engineer and AICP, just make clear in your retainer agreement what your sole role is so that you're guided by a single code, and then make clear to the public forum that you're operating under one set of rules, and that's the rules that you're operating under, and stay that course.
You know, Dwight, I had some experience with this some years ago when I was doing some consulting as a lawyer and planner. And a town had hired me to draft a moratorium on development because they were faced with an extraordinary situation. A single development would have doubled the number of housing units in the town. And so they wanted a little breather. So I drafted that, and of course the town got sued, and I was called as a witness in the trial. And the town's attorney wanted to keep the emails that I had sent to the planning board chairperson out of the public record, out of the trial, and made the argument that as an attorney, and I had represented myself to the town as an attorney, this was protected by attorney-client privilege, and the judge agreed.
Well, they can be tough. These can be tough issues at times.
Yeah, we're going to take actually, why don't we stop and
Yeah.
take a look at a couple of questions here? We've got
a lot of questions here. I'm really glad that we have so much interest from our listening audience.
A quick one for you, Dwight.
Tell where to start here.
Are all lawyers members of the ABA?
Are all lawyers
answer that.
members of the ABA? No, they are not. Less than half, substantially less than half, are not members of the American Bar Association. However, the state rules of professional conduct, or adopt, or whatever they're called in their respective states, are state rules regardless of their membership. If they're a member of that state bar, that is their license, they are bound by those rules. So the ABA promulgates model rules, the states adopt rules, you're bound by the state rules. Every lawyer is bound by some set of rules.
And in my experience, the state rules tend to mirror the ABA's model rules.
They do.
Although
Which,
there are some
you know,
differences.
brings in a second question, kind of an unrelated but related question. Somebody says, one of the questioners here says, look, I'm a member of AICP. I've got all these rules. Does that put me at a professional disadvantage relative to planners who are not AICP? Well, my answer to that is being a certified planner is a substantial credential that gives you credibility beyond someone who's not yet credentialed, at least in my personal and professional view. Besides, I think these ethical standards are ones that I would want to follow whether there was a code or not.
I'd agree with that.
Yeah. Yeah, and you know, Dwight, when you were talking about number 8 of the Code of Ethics, where we're talking about private communications, I know we're going to talk a little bit more about this as we move through the presentation, but since this was written, and be it now 6 years ago that this was adopted as our code, here we are with all this new form of social media and using those types of communications, even to get the word out for public participation. And it just, it kind of adds an interesting layer as to how that rule gets interpreted anymore. Your thoughts?
Well, I think the guidance in this area, Anna, that I see frequently is people will say to me, or I've heard them say to others, look, let me just tell you, between you and me, can this just be between us? I want to tell you, and then they start to tell you something. in virtually, not every, but almost every case when somebody does that with me, I say, no, really, you can't. We can't have that conversation. I've got an obligation to my clients. I think planners in that situation really have to be wary about letting that conversation go forward under B8 without saying, I can't, I can't have that type of confidence with you because I'm in a public position here. Somebody could depose me later and ask about this conversation. I'd have to reveal it, and let's not put ourselves in that position.
Yeah.
So that goes for email, that goes for phone conversations, that goes for someone posting a message to you on your Facebook wall. All of those are included.
Yeah, we're going to get to the social networking, but yeah, you have to be so careful today.
All right, why don't we move on to some of the state public ethics laws so we can at least get through most of the material today. And we're going to start with Florida. And I took a look at the Florida standards for public officials. It is, in my view, an extraordinary law. It is rich in definition and standards. It deals with anti-nepotism and has I think what I call a thorough but limited definition of what the word relative is, what it means, which is particularly helpful. No gifts whatsoever, and of course no influence peddling. But I guess my complaint about the Florida statute is that I hit print and it came out at 59 pages. It's a long statute. I have a hard enough time getting planning and zoning board members to read the planning and zoning statutes, much less a 59-page long ethics statute. But Florida does have a commission on ethics that is by statute the guardian of the standards, and they have a lot of information that's available to public officials. This covers not just officers, but employees at all levels of government in the state, and that means right down to municipalities. Even with
municipalities, Ben, yeah, I was just going to say that when you and I were talking about Florida's complexities, we were talking at the same time about a straightforward provision in Minneapolis that we put into the program materials. And it's not the whole code by a long shot, but it is a pretty simple, straightforward treatment. And what it tells me is a couple of things. One, if you don't have an adequate state code, you can have a local code. Write your own code on conflicts. And but what's interesting about Minneapolis at the same time is that they talk about a conflict of interest, about a financial interest, but they don't talk about a personal interest, which is usually hand in glove with the financial. One thing that they do in this code that many of the state codes don't that we looked at is they talk about domestic partners, which the other codes refer to spouse and don't define spouse. And I don't think they're up to date in the way our households and the way people live today.
Now, even with its very rich and broad state statutes, Florida has a lot of ongoing state and federal prosecutions of public officials who've been alleged to engage in illegal activities based upon their position. In late 2009, Governor Charlie Crist petitioned for the formation of a statewide grand jury. That was formed in 2010. And it's specifically to investigate ongoing harm of crimes committed by local and state officials acting in their official capacity. That statewide grand jury has issued last month an interim report, and we have the link to that there. Its commission expires next month in February, so I think we'll be looking for a final report there. But there are some recommendations in the interim report that are, I think, particularly interesting. One is that the state statute should be amended to apply not just to public officers and employees, but also to private contractors doing business with elements of state government and local government. And that, I think, could have a significant impact in the ability of prosecutors to go after criminal actions. And so that's it for Florida. What about Oregon, Dwight?
Well, like many things, Oregon is a leader. They really have an excellent state code, and they have a wonderful guide for public officials. And if you go to the site, I encourage you to take a look at the guide rather than read the statute. But you know what the guide tells me, which is so on point here, is that, and I quote from it, "This means that each public official must make a personal judgment in deciding such matters as the use of official position." And then they go on to say, "Since compliance is the personal responsibility of each public official." I think that's really right on, and they emphasize that throughout. They have a nice piece on financial benefit. They have another piece on conflict of interest, which is worth reading. They have a comprehensive section on honoraria, which is often a problem for our professional planners. Come give a talk and we'll give you a $200 honorarium. Well, you know, can you take that? Should you take that? How do you manage that? What do you disclose it? And so forth. The one thing that Anna, Ben, and I were talking about is the business of taking gifts. And I think it's fair, if I could speak for the three of us, that we pretty much decided that the best thing to do is just have a zero tolerance policy here. Just say, no, no, never. Yes. It's not worth it to make a $50 rule or $100 rule. And I tell you, the most dramatic example, town manager, one of the best town managers I've known in my life, and he had a meeting of a half a dozen of his senior staff with a developer in the town hall. The developer walked in with one of those boxes of coffee that you can buy for 20 people, cream, sugars, and I guess some donuts, and set them down the table and said, "Now let's talk about our project." And the manager said to all his staff, "Time to pony up." And staff reached in their wallets and put their money right on the table, gave it to the developer. They wouldn't take a cup of coffee and a donut from the developer. And I think that's right, exactly right. I think that just sets a tone. You don't have to embarrass somebody. You just say, we understand, we appreciate your generosity and your hospitality, and but you know, we just don't ever do it, period. So take a look at Oregon. Mm-hmm. So we've got some very good things there for us.
And I think, Dwight, Pennsylvania also has like provisions. The Pennsylvania Ethics Act has been around for a while, having spent almost, well, all of my career there practicing planning other than the last 3 years. I was much more familiar with that Ethics Act, but basically what's interesting is it does, as in Oregon and Florida, it applies to both public officials and employees, also public or political candidates and nominees. Now, what's interesting is there is a statement of financial disclosure that must be filed annually, and I over the course of my career, I worked in both public and private sector. When I went from public to private sector, I was amazed that I still had to fill out the statement of financial disclosure because I was working for public sector clients. And as a consultant, they still had to file what my personal finances were about. I also like the fact that there are required waiting periods, as I call them, that if you are working for a state government, for instance, or you're a state employee and you leave, retire, whatever, you cannot go back and work for or represent a client that for the agency, in front of the agency that you were gainfully employed less or unless it's more than a year. If you are an executive within an executive position, it's 2 years. So I get to Maine and figure, oh, there's got to be a State Ethics Act. Well, there is. It's called the Governmental Ethics Law, which is only applicable if you are a member of the Ethics Commission or a legislator. There's nothing to prohibit a professional. For instance, if I was to leave Brunswick and go and work for an area developer, there is nothing that would restrict me to come back and represent the plan in front of the planning board the next day. Basically, there's nothing that applies to address that. There are conflict of interest provisions, but that's about it. We're a home rule state.
Mm-hmm.
So
that's interesting because New Hampshire is not a home rule state, but has a similar standard that applies to executive employees, but nothing to lower levels of government. And I think this situation would apply. But there, I think you need to turn to the code too and see what that would say to that kind of practice.
Right, exactly.
We have a couple of questions I think we want to get to.
Yeah.
Yeah, and I would just, somebody commented on my comment about the AICP credential, somebody from New Jersey who said, well, you know, we have, there's the Professional Licensing Board, but New Jersey's unusual. Most states don't license planners as such. And
I think only New Jersey
and
and Michigan.
Yeah, and I certainly don't mean to disparage people who are not AICP members, but I do mean to say that I don't think AICP members are at a disadvantage because I think the credential is valuable, and I think we would all want to follow that code regardless. And somebody complained about my comments about the donuts. You know, I think what was so strong about that message was that you know, I don't want, if I'm a manager, I don't want my staff to have to worry about where the line is drawn. And by just, it's not worth a cup of coffee or a donut, frankly. And this last question, do you see this one up here? Is it ethical to attend an opening reception hosted by a developer and to which important elected officials and city departments are invited to celebrate finishing a major project? I think it is. It depends, you know, if it's overly lavish, then it's questionable. But if there's a broad invitation list, I think that's perfectly fine.
And I caught a lot of grief from my staff when our new town planner came on board over a year ago, and a local engineering firm down the block wanted to have us over for hot dogs on a Friday afternoon in the summer to welcome Chris to the fold. And I said, So, and you know, in small towns, it's a matter of appearance as well, but I just felt very uncomfortable. They do a lot of work in town.
But this is an opening reception for a project, and we're going to assume that the contractors and the neighbors and the potential tenants and the marketing people are all going to be there. You know, I think staff and the elected and appointed officials are obligated to be there. They should be there as part of their public responsibilities. Now, if they have a, you know, a $200 sit-down dinner and a name brand entertainment, now you're into another realm, I think.
Right.
We have another question that harkens back to whistleblower laws. Is there any protection given to planners and or other professionals should one choose to speak out against a client and gets terminated, sued, etc., in upholding an ethics standard? I know some states do have specific whistleblower laws that protect people from wrongful termination, as it were, for revealing that sort of thing.
Well, I don't know. I don't know one
employees.
I don't know any specific to planners. I will tell you, and Anna, you're going to be the president of AICP. When I was president of AICP, we had the amicus curiae committee, when I was involved on that committee, the friend of the court committee, involved in a local firing situation for a planner because we thought it was important enough to APA. So I would encourage anybody who thinks they have an employment situation to get a hold of Paul Farmer or somebody else who can potentially intercede on their behalf.
And way back when, and I think probably after you were president or maybe even during Dwight, we had what was called the Planner Support Network that could at least guide or give some direction to someone who was in that type of situation, and 9 times out of 10 it would have been referred to our ethics officer. So it winds up going back to Paul.
Well, why don't we wrap up this session by taking a look at a couple of federal issues, and the question I have is, well, what does Enron have to do with planners? And you might at first blush say nothing, but in fact, I remember Jeffrey Skilling, former CEO of Enron, which was once the 7th largest grossing corporation in the country. He was prosecuted over the last few years for, among other things, insider trading and what's called honest services wire or mail fraud, and there's a statutory citation to the U.S. Code there. Section 1346 of Title 18 prescribes fraudulent deprivations of another's intangible right of honest services. So you hire someone to do something, you have a right that they're going to do so honestly. And he was convicted on 19 counts of honest services fraud, and that was appealed to the circuit court, which upheld the trial court's decision, and then appealed to the Supreme Court. And last year, in a landmark case, the Supreme Court decided, first off, that this statutory provision dealing with honest services was not unconstitutionally vague, but they limited its application under the statute to bribery and kickbacks. It does not apply to the undisclosed conflicts of interest or self-dealing, and that really was one of the linchpins of the prosecution's case. So this has been remanded, and the Skilling trial continues on. But this relates to planners and local government officials, in part because there are a lot of cases still being prosecuted alleging honest services fraud that deal with bribery and kickbacks. And I've read a couple of articles that cite many, many cases, New Jersey, Florida, elsewhere. And these prosecutions are ongoing. Congress may fill the gap and essentially override the Supreme Court's Skilling decision. The court simply interpreted the statute, and the Congress can go back and change the statute, as they did with this law back in the 80s. So we need to be aware, first off, if you're engaged in honest services fraud and you know it, and it's based on a conflict of interest, chances are right now you're not going to go to federal prison for it, but you may get prosecuted for other reasons. So just be aware of that. Another issue is signing on the dotted line, and this is, I think, a sleeping giant. This is not a case that went to trial. It was settled. This is the United States versus Westchester County. This is an action that was initiated, first off, by the Anti-Discrimination Center of Metro New York. When the Obama administration came on board, they picked it up. The Department of Justice got involved. HUD got involved. The case involves the Federal False Claims Act, which is a Civil War era law that was intended to go after manufacturers of shoddy goods. And it has been applied here to Westchester County, recognizing that when you're accepting federal money, such as community development block grant or home partnership funding, a variety of federal funding, you give assurances when you sign the forms that you're doing something in particular. Now, with regard to HUD funding, recipients of CDBG and other similar fundings have to prepare a consolidated plan, and part of that consolidated plan is an analysis of impediments to fair housing, which demonstrates that that jurisdiction will affirmatively further fair housing, which means in part combating racial discrimination. And Westchester County dutifully signed those forms. They did their con plan. They did their analysis of impediments, which demonstrated that they were affirmatively furthering fair housing. And the Anti-Discrimination Center said no. Department of Justice said no. And the federal court finally agreed to a settlement. Westchester County was potentially liable for up to $150 million in damages. They settled for something on the order of $50 million in 2009. And what this means is they've got to go build or acquire affordable housing, and most of that's got to be located in mostly white communities. And they've got to prepare a new analysis of impediments. They did that and submitted it to HUD, and last month HUD rejected it as being inadequate because it simply documented the impediments. It didn't indicate what the solutions would be. And I think looking at the situation of Westchester County here, they're the direct recipient of CDBG money, and then they send it out to municipalities. They don't have control over the zoning of those municipalities, but they do have control over who gets the money, and that's really the issue here. We're looking for more vigorous enforcement of the False Claims Act and of the housing standards. HUD has promised that guidelines are forthcoming. They said that in late August of 2009 after the settlement was agreed to. I talked to a high-level HUD official recently who said, yes, it's forthcoming, but they're having some difficulty right now with the settlement and figuring out how to implement it. So we're still waiting. As I said, I think this is a sleeping giant for any municipality, any level of government that is receiving federal money. Be careful. When you sign on the dotted line, make sure you've read that fine print and you know what it is you're saying when you sign. That's what the issue here was in Westchester County.
Yeah, as I say, anybody that's getting community development block grant money has to make these certifications, and being an ethical planner means asking the hard questions and looking sometimes behind what's given you and then deciding in consultation with your community leaders what your obligations are to disclose. Well, are we finally to some of our scenarios?
Move into some ethics questions.
Yeah.
Well, we still have a lot of questions from our listeners. I would just say that we got a couple people written in and say they really like the zero tolerance rule in the coffee and donuts. So I'm vindicated. Somebody asked what home rule was. Ben, you want to explain what home rule is, because that's a basic concept here.
Well, states operate under one of two forms of authority. One is home rule, and the other is what's known as Dillon's rule. Dillon was a 19th century lawyer who wrote a treatise on municipal corporations. Home rule means that the power of municipalities is inherent except for that power which the state government specifically reserves to itself. Dillon's rule is just the opposite. In a Dillon's rule state, a municipality that wants to do something has to look for state-enabling legislation.
And then one question, very direct, straightforward question, is it ethical to accept a current consultant offer to pay for lunch? The consultant is already on contract. All our listeners, some 1,000 listeners, 1,000 sites we've got today, you just mark down the answer here. It's a pass-fail exam. I got an idea what the answer is. Anna, Ben? Current consultant already hired says, let's go to lunch here. I'll take the tab.
Nope.
Nope.
And I'm seeing no's coming up.
Nope. Nope.
Thank you. No, no. Oh, here come the votes. But yeah, no.
Yeah.
All right. Well,
yeah.
All right. You can stop sending your answer no, because really, think of the light of day test. It comes out in the local paper the next day. Planner Mary Jones had lunch with consultant XYZ engineering company, and it was a lovely lunch, and they paid for it. I don't think so.
And just,
all right.
just as a matter of protecting yourself, though, I think you need to make sure that you get separate bills and you keep your receipt.
Right. And,
I like that idea. That's a good suggestion.
And looking at it both ways, those in the private sector, and I've been on both sides as well, and it's awkward at times, and not to just think about it, a private sector planner, just think about what you're doing. If you are offering, if a public sector planner says, no thanks, accept it as that. Better yet, don't even approach it. Just make sure that it's separate checks and be done with it.
We have the flip side question here. As a public employee, after the contract closes, can I buy the consultant lunch as a thank you?
No.
Well, I suppose you could, but if I were that planner, I wouldn't do it. I wouldn't do it again, because the light of day test, the second thing is somebody looking at that is going to say, hey, this planner's trying to get a job with this consultant while, even though the contract is over, they may come back for a second or third contract. You do lose something in being a public official, just like I as a lawyer have a lot of ability to comment publicly on things because I can't without causing potential harm to my clients. And we give something up by serving publicly or serving in certain professions. And, something else you can do, maybe have them over for have them as one of 20 guests at a cookout.
Yeah.
And thank them there. Or make them something, a little craft and give it to them. Or just a thank you notice sometimes are really what people need. The thing that we had the most fun in getting ready for this was talking about, do you want to friend me? Ben and Anna, I didn't tell you, but this morning the ABA Electronic Journal had a release. A very prominent law firm, to save them the embarrassment, I don't want to, even though it's all quite public now, ABA's Electronic Journal, a partner in a very prominent law firm, was critical of opening the Tucson prayer ceremony with an Indian prayer. He referred to it as, quote, ugly. Had no mention of God. He said several of the victims were definitely not Yaqui, the Indian tribe on which the prayer was based. The partners of that law firm have now had to publicly apologize. We see this every day on these blogs and social networking sites. Do you see big advantages to these social networking sites in doing our job of increasing public participation and information? And on the flip side, what is the downside here?
Go ahead, Ben.
I see great advantages to it. I know my organization is on Facebook, and I have a professional Twitter account. Not too many people follow me, which hurts me deeply. But there's a certain color to things, and you have to be very careful about what you put on there and how you respond to things. And one of the downsides, I think, is that you have to police it, because these things they're not wholly publicly available, but people can read them if you enable it. And if someone is putting something on there that is defamatory, you've got to clean it up, and fast. By the same token, not everyone has access to it. So it's not, although it's a great way for, say, on Facebook to get feedback on a master plan, it's a great way to get a lot of feedback from people who otherwise would not participate in the process. It's not, it is not universal and should not be treated as so.
Well, Anna, before you go ahead, I'd just point out that a third of Americans have a profile page on a social networking site. A third have a profile page on some social networking site. They're out there.
And that's growing fast.
Right, and I kind of alluded to this a way back in the beginning of this session that basically, you know, if you are hit with, as public sector, if you're hit with a FOIA request, even private sector, if you're being brought into a municipal lawsuit, Dwight may, I'm hoping he will chime in here, but what you put out there is also...
Oh, it's all discoverable. Yep.
Yeah.
Well, I first of all, we use social networking sites in all different ways. The American Bar Association section I chair has a Facebook page and has a Twitter account. Charlotte, North Carolina had 700 participants online on a light rail issue. San Jose, California had 5,000 people weigh in on the planning process. But here's what I would just touch on, because we've only got a few minutes left, are the big issues. Ex-parte communications, communications outside the hearing, freedom of information and records retention issues, access for people that don't have computers. While the rest of the world is talking about issues of great importance, there is a substantial disenfranchised population if they're not online. Truthfulness of the claims. Whether we make our people weighing in on public issues register, and on the other side of that, how do we protect their privacy? And confidentiality issues. I looked at one of the listservers I belong to with planners. A planner sent a message. This is to hundreds and hundreds of people. Well, in my town, we got a problem. We don't know how to interpret what it means by a majority of the commission. Is that, you know, the people here, the total commission, the alternates, or not? A lawyer answered, my opinion is, and gave his whole legal opinion on it. He doesn't have a client there. And then another planner from another town weighed in and said, you know, I agree with you. Well, those two planners and the lawyers may have those messages held up in their face by somebody later on. So it's trying to risk it.
Yeah, and all part of the social networking, social media now that we're not even talking about is blogs. And the anonymous, or, well, the alias name blogging messages that are very, they can be very dangerous to projects that you're trying to present, and just be misleading in content. It's part of our age.
Ben, I'm looking at my clock here, and I think just as we predicted, we weren't going to get far into the scenarios, and that our listeners would have an opportunity to read those in their with their people in their businesses and discuss them. Maybe we might do the first one, the too good to be ethical one, which is kind of interesting. But I would ask you, if you could, to look at the question posed at 22 after the hour about the developer who left the ham at the planner's house.
I love it.
If you could just read that as we close this out. Do you want to talk about too good to be ethical, or are we going to be out of time?
I'd be happy to. If you could find that question, I'll go through too good to be ethical. So you have a,
and I'll be ready
local
to read
retailer.
It.
A local retailer gives 50% discounts to all municipal employees to give back to the community. This is a local person who's trying to do good for the people who work for the town. But he's expanding. He's doing so well. He needs more space, and he's also applying for an impact fee waiver, which requires some sort of staff recommendation. The planning director's husband is an employee of the retailer. The director and all other staff members are recipients of the discount. What should the town do in this situation?
Oh, we're supposed to answer that?
Yeah, it's up to us.
I'm just giving people a second to think. Here, I think there are a couple of different things that have to be parsed out of this. First off is the planning director's conflict. Because the director's husband is an employee, there's a direct pecuniary interest there, and the planning director needs to step away from this. But then the broader question is, are all staff members tainted by the 15% discount? In one situation in which came to my attention, there was similar to this. In fact, the town decided to discontinue the discounts and to simply eliminate that. But when we were preparing for this, the three of us talked about, well, what about senior discounts? What about public employees getting, or teachers getting discounts at craft supply stores or for classroom supplies? Is it fair to punish them from getting that discount simply because they're going and trying to supply their classrooms? I don't know. I don't think so.
I think too.
Yeah, I sort of think it's okay if it's a broad enough group that's getting it on a regular basis. Yeah.
Right, and that's what I was just going to agree. Well, agreed, and I also give the example. Even Verizon generally gives discounts to municipal employees, and it's a very big big recipient. It's a big group that's getting that benefit. It's not a person. So I think that's important to keep in the back of your mind.
Well, Ben, we don't want to hold people over. I want to thank you for your leadership in making this happen, and I want to read, just to put this in the larger perspective, a short anecdote related to us by one of our listeners today. A local contractor dropped off a ham at my home just before one year, many years ago. I was out of town, and upon my return, I noticed a plastic ham wrapper in the front yard. My outdoor cats were quite overweight and wore big smiles. I asked the contractor not to give gifts anymore. My cats hate me now. So there are burdens to being ethical. This is one of them. You could end up with your cats hating you, but you got to do the right thing.
Yeah.
You got to do the right thing at all times. I think we need to close this out. Anna, Dwight, thanks so much for joining with me this afternoon. It has been a lot of fun.
Well, thank you for your leadership, Ben.
Thank you, Ben.
Yes, I just like...
As President, Anna.
Thank you. Thank you very much.
Yes, I just want to thank the three of you for having this wonderful discussion on ethics today. For those of you still in attendance, just a little reminder to log CM credits. They are up on this website, so once you log off here, you can go and claim those credits by going to www.planning.org/CM and then select activities by date, and then underneath January 21st, you'll find planning ethics across the country. And like I said, this is up, so you can go claim those. And then we've also been recording today's session, and so you'll be able to find a PDF and video recording of today's webinar at www.utah-apa.org/pastwebcast.htm, and then this should be up by Monday. So that concludes today's session. I just want to thank you again for attending.
Okay, are we muted, Cody?
No, it's
Are we
still...
on air now?